Namaskar. In this episode of Dil Se, we'll talk about an issue that has troubled me personally for a long time, but I think has troubled members of the legal profession, hopefully some members of the judiciary, as to how governors are conducting themselves in the discharge of their constitutional functions. We all know that the office of the governor was created as far back as 1919 under the Act itself. And every governor acted in accordance with the wishes of the legislature, because governors have no independent role to play in the formulation of law or in the passing of bills, though they are part of the legislature under our constitution. And the office of governors, by and large, was respected by those who took those positions over the years since 1950. But things have changed since 2000 and when Modi ji came to power in 2014. Now, why have things changed? It's because governors are no longer respecting traditions and the way governors should act under the Constitution. Many of them have openly said that they belong to a particular ideology. Some of them have openly said that they follow the RSS in the discharge of their duties. Others have said that no, the office of governor is a proactive office. And we've seen governors attempting to do politics within the states, in fact, destabilizing states. They now don't even read the address given at the beginning of a session by the government to the governor to read in the House. And they make changes even there. They walk out as and when the address is being read by them. So we have a lot of problems, and this has created a lot of despair within the system, especially state governments, because they feel that governors are acting as political agents of the powers of the center. So this is the issue that I want to discuss today, in the context of a judgment recently delivered by the Supreme Court by a bench consisting of Justice Pardiwala and Justice Mahadevan, in which they have set timelines for governors to clear bills, to give their assent or not to give their assent. And that has created a furor, and the government in turn has sent a reference to the Supreme Court of India to answer 14 questions in that reference. We'll talk about that with three extraordinary guests that I have today with me. I have Justice Patnaik, who has been a judge of the Supreme Court from 2009 to 2014. He was admitted to the bar in 1974, and in 1994 you became an additional judge. Then you went to Orissa, then you were sent to Chhattisgarh, where you were Chief Justice, and thereafter to Madhya Pradesh, and came to the Supreme Court in 2009, and went on to be a judge since 2014. So you have enormous, what should I say, experience in the context of the fact that you are also an academic. And I know you for a long time, way back, and your bent of mind was always very academic. So you combined your academic with your judgments, and they make great reading. So thank you very much for being here. Dushyant is an old friend, member of our profession, and perhaps one of the bravest lawyers that I know of since independence. Wants to call a spade a spade. And he has done some really difficult cases and taken on the government in most matters. He has also tried to protect the secular fabric of this country. His father was a judge of the Gujarat High Court, and he came to the bar in 1978, moved to Delhi in 1986, and ever since he has been proactive, trying to protect the weaker sections of society, the kind of attacks that are made against minorities. He stands up for the minorities. And also, he is deeply involved in arbitration. And he's been on the board of arbitration of several organizations throughout the world. So thank you very much, Dushyant, for being here. Justice Murlidhar retired as Chief Justice of the Orissa High Court, BSc from Madras, LLB from Madras, 84 enrolled as an advocate, stood first in the AOR examination, always was first in his class and top class academic, and wedded to the cause of the poor, wedded to wherever there is injustice, he always stood up. I knew as a lawyer, and as a judge, completely unafraid, he paid for it. In fact, both Justice Patnaik and Justice Murlidhar paid for it, because Justice Patnaik, 2007 to 9, you were the senior most judge and they never brought you in Supreme Court. And Justice Murlidhar, the Delhi riots case, gave a hearing at midnight, was transferred overnight to Punjab Haryana High Court. Of course, from there he went to Orissa, and people swear by him in Orissa. He changed the whole, IT system in Orissa, paperless courts. And, if there is anybody who speaks truth to power at any given point in time, it's you. Thank you, Murli. But Naik Saab, what do you say? What's happening to the office of the governors? And what do you think of this Justice Padiwala's judgment?
The office of the governor, as you rightly said, has become politicalized. And they act not as per the provisions of the Constitution, as per conventions, as per traditions. But as to what would be proper for him to do, taking into consideration that central government is now with the BJP. And there's a great difficulty. And number of cases now came to Supreme Court where the governor is not giving assent to the bills. And this Padiwala's judgment has sorted out these problems. See, the Constitution is silent. It's correct. The provisions are silent in Article 200 and 201 as to the timelines. And except in the case of governor, they say as soon as possible. Yes. So these, in the absence of these provisions, express provisions, something had to be done by the court.
But does the Constitution can the Constitution have timelines as to by which time a governor should give consent to the president? It can't.
No, it is expected for the governor to act. The words as soon as possible are there.
Yes, exactly.
Right. So therefore, in the absence of any constitutional provisions to the effect, I think the judgment had to do complete justice, come in, bring in aid, Article 42. And remember, he has not said that timelines are mandatory. He has said that these timelines are given to ensure that if he does not act, then the matter can come to court and become part of judicial review. That is in that context he has said. Justice Padiwala has made it clear that these timelines are not because we are amending the Constitution or changing.
No, but he has certainly provided timelines for the governor to act.
But timeline, you have seen some paragraphs. Yes, so the timelines are given because if this is not done within these timelines, then the state can come to the Supreme Court or the High Court and say, please look into it. And had made him justiciable. I have carefully read the judgments. He has made this very clear.
Mm-hmm. But Dushyant, these bills, 10 bills which are not cleared by the governor, has been languishing since November 2023. We are in 2025. So can a governor for 2 years just latch on to bills and not clear them?
See, absolutely not. One thing is very clear, that the conflict between the elected representatives of the people in states and the governors is only taking place in the states where people have chosen to elect non-BJP governments. This conflict is absent in the states where BJP governments are in power. And the governors are willing to pass any and every bill give assent very quickly. So it clearly shows that there is a clear design on the part of the executive at the center by appointing chosen governors to ensure that the functioning of those states in which there is opposition government is stalled as much as possible. The idea being that the policies of the elected party and the promises which they have given during the election, those promises are not fulfilled and therefore they are projected as failure for the next election. This is seriously, a gross erosion of constitutional morality, constitutional values, and there is no doubt in my mind that the governors are acting at the behest of the executive at the center and for collateral consideration. Now, one thing is very clear, under the Constitution, nobody is imperio in imperium. everybody is under the constitution, whether it's the president, whether it's the governor. Secondly, every power which is given under the constitution, there is no need to fix a limitation under the constitution. That power is expected to be exercised within a reasonable period of time. And if Article 200 says that a governor has only two options, either he grants assent or he refers it to the president. Now, if you have to grant the assent, then naturally you can't sit over it and say, I will grant assent after 5 years. It has to be granted because the will of the people has spoken. Therefore, you have no option. This is a parliamentary system in which we wanted, as Ambedkar said, more responsibility than more power. Now, governors are therefore expected to be responsible. Otherwise, Dr. Ambedkar and his colleagues would have chosen presidential form of government. They didn't want that. They wanted a parliamentary form of the government. So, I think this kind of I would say it's a gross abuse of power on the part of the governors. And I think judgment of the Supreme Court is an absolutely a correct judgment. It lays down, same line as some Singh's judgment and other judgments have spoken about the power of the governor. And I think the reference is in a poor taste. And I really hope and pray that Supreme Court respectfully returns the reference to the Honorable President.
But Dushyant, there are three options that are with the governor. He can assent, he can send it to the president, but there's a third option. They can send the bill back
with
a message.
Correct.
And if it is passed again under 200,
correct,
then it has to be cleared by the,
correct,
which is what happened in this case.
But again, there is no time limit. Shall does not mean. So, question is, does he sit over it? Does he have a right?
Correct.
Nobody has a right to sit over. Your power is given it's coupled with a duty. And if you fail in that duty, then naturally court has to step in and remind you, however high you may be, that sorry Mr. President, sorry Mr. Governor, but you have not done what you are expected to do under the Constitution.
It's a very subtle reasoning that Justice Pariwala gave. He said the power is to withhold assent.
Right.
Withhold defer assent.
Right.
Not to give assent.
That's correct. So you can't withhold it from November 2023. Murli, let me just bring you in for a minute. In 201, when the matter is referred to the president, there is no reference of as soon as maybe.
Correct.
Right?
Yes.
What's the implication of that?
So the judgment notes the distinction between 200 and 201, but says that since constitutional authorities are expected to respect the spirit of the Constitution and to make sure that the purpose of sending something for approval of the president is expected to be done in an expeditious manner, even though there is no time limit set there, we have to read in certain time limits. In fact, there are many such functions where if you don't do it within a certain time, and the Supreme Court has stepped in earlier occasions, including, for instance, disposal of mercy petitions.
Right.
So these do matter, and the judgment notes very significantly this aspect. A government in a state is elected for 5 years.
Right.
And Kapil, I think some of the bills were pending since 2020.
Yes.
The judgment notes it's been pending since 2020. And it was also there before the earlier governor, and when he was replaced with the present governor, that continued. They simply sat on it.
Correct.
So the judgment correctly asks, what is the will of the people? And if you sit on doing nothing. So this is one part. The second part in the judgment is the absence of the three words in his discretion, which was there in the 1935 Act, correct, which is missing in Article 200. So even returning it to the Assembly for reconsideration has to be on the advice of the Council of Ministers, which is why the judgment notes that the B.K. Pavitra judgment earlier is per incurium, because even this act the governor can do only on the aid and advice of the ministers. And likewise, the president, while granting or refusing withholding assent, has to do it only in the aid and advice of the Union Cabinet. So I think the judgment sees the whole provisions, the two provisions for what they really are. One, it sees that neither the president nor the governor is exercising any discretion. In fact, the two questions which have been referred to in the 14 wrongly say that is the discretion of the president and is the discretion of the governor justiciable. In fact, the judgment is very categorical, saying there is in fact no discretion. You're only acting on the aid and advice in the case of the governor of the Council of Ministers in the state and the Union Cabinet as far as the president is concerned. So the tussle really is between the union government and the state government, and that is what the judgment actually sees as happening in this case.
Yeah, but you know, in Raman Rebia's case, the problem is that in that they said that there are 3 discretionary powers of the governor, right? These questions didn't arise in that Raman
No,
Rebia's
so the
case.
area of discretion is this, like for instance, inviting someone to form the government.
No.
Appointment of the
Wait,
chief
200.
minister.
They have said,
So the proviso to 200, and that's what this judgment notes.
That's right.
The proviso to 200 says if it's going to affect the powers, the jurisdiction and powers of High Court, then the governor does not
confined.
have to act on the advice of the ministers.
It's an extremely limited and
And that's
I'm just saying that is why in the reference they have made, what can the discretion of the governor be interfered with?
No, but
because
only for the
from
proviso.
Navam Rubia,
yeah, but only the proviso to 200 provides one area of discretion in the context of 200.
Correct.
In the context of, let's say, 164 and others, there is a different set of discretion. I mean, limited again, available to the governor, again available to the president.
Absolutely.
So, and if I may add this, see, there are 2 phases in which we see what has happened to the office of the governor. Because of the comment you made, I think it dates back much earlier to 2014. The devaluing of the office of the governor. If you remember the run-up up to S.R. Bommai, there used to be en masse dismissal of governments when a government changed at the center. And twice it was taken to the Supreme Court, and twice I would say the Supreme Court disappointed the people by upholding those dismissals. It was only when Bommai came,
Correct.
they said you can't misuse the office of the governor like this to generate reports about breakdown of constitutional machinery. So Bommai is a watershed. The other was the Bihar case when post Bommai, out of the old habit, they again tried to dismiss when Mr. Bhuta Singh was the governor of Bihar. I was part of the case as counsel to the Election Commission. The court invalidated that. So the number of instances of trying to impose president's rule through a report of the governor has come down drastically after Bommai. And even this dispensation, whenever they've tried to do it, they've met with resistance. Resistance. So I think this is another front that is opening up just to complete this.
let us put it this way: the governor does not exercise checks over the functioning of the parliamentary democracy in a state.
Right.
Governor has he's a constitutional head, he's a figurehead, and governor therefore cannot defeat the will of the people by either his actions or his inactions. Now if the governors do this is exactly what Chief Justice Murlidhar points out, that after Bommai there is now a new line of limitation on the power of the governor. Now, what they are therefore doing, that I can't do it directly by advising the president to dissolve the assembly, but I will rule the state in this fashion.
So Dushyant, there's a very interesting thing as a reference to the state of Punjab decision in this. In the state of Punjab, the governor refused to convene the assembly.
That's correct. And then there was
which is remarkable. A budget session had to be convened.
Not just Punjab, even in Telangana. And I advised the Chief Minister to file a petition in the High Court. I went and argued, and then Chief Justice was Justice Boyan, and he said that, Mr. Dave, why are you embarrassing us by bringing this before the court? I said, we are left with no alternative. So then, luckily for us, the governor, Her Excellency appeared through a lawyer. And then I said that I will talk to governor's lawyer during the lunchtime and maybe, bring about some rapprochement. And I spoke to him. He said that Her Excellency is very upset that the Chief Minister or his ministers are not calling upon her ever, for anything. So then I told Honorable Chief Minister that please don't allow this situation to like this, because the budget session she is not convening. And under the Constitution, budget session has to be convened within a time frame. So luckily,
but in Punjab, it required a judgment of the Supreme Court.
That's right. Yeah. The Supreme Court said, yes, you have to hold. Anyway, I think there are 2 separate issues. I think the power under 356 has been misused for a long, long time.
Correct.
But I was not on 356.
No, you were not.
I am on when the legislature passes a bill. And in that context, the governor for 2 years, 3 years, 4 years does not clear it. This is the new trend that has started in 2014.
I think governor cannot even sit beyond 30 days, to my mind.
Now the Supreme Court.
You are destroying will of the people in this fashion.
But I think we're missing something here because of the nature of the office of the governor. Yeah. This is one of those offices which is held at the pleasure of the president. which means a governor can just be removed overnight. So I think it's nobody's,
That pleasure is never exercised.
no, they do remove governors.
No,
When
no,
a government,
only in opposition states, never their own.
that's right. No. So when the government changes at the center, and this is a consistent pattern.
That's a separate issue.
No, so which is why the governors act the way they do.
No. They are acting not because of the fear of being removed.
No.
They are acting because they want to curry favor with the party in power at the center.
I think,
They are their spokespersons.
No. Either way, I think the
I mean,
point
you
I'm making
see-
is it's not an independent office at all.
You see the statements
was
made
never-
by Governor of Kerala, who's now Governor of Bihar, statement made by Governor of Tamil Nadu, and many other governors. Those statements are really, I would say, they are extremely disappointing. That coming from such a high office, such statements are being made. I mean, it really shocks that this is not what the constitutional framers had in mind. If you see the Constituent Assembly debates, throughout Ambedkar said that we have left little or no discretion at all with the president
Or the governor.
Yeah,
So this
I just quote what Ambedkar, he said, the aspect of the question which is material is the governor going to have any power of interference in the working of a ministry, which is composed of a majority in the local legislature? If that governor has no power of interference in the internal administration of a ministry, which has a majority, then it seems to me that the question whether he is nominated or elected is wholly immaterial. If the constitution remains in principle the same as we intend that it should be, that the governor should be a purely constitutional governor with no power of interference in the administration of the province, then it seems to me quite immaterial whether he is nominated.
That is why indiscretion words which existed prior
Right.
to the Constitution,
Was taken
the
out.
draft were taken out.
Yes. But the proviso had that's limited.
Only for when it interfered with the powers of the High Court.
because that is to maintain the independence of the judiciary.
That's right.
That is a very separate issue.
Right.
If the assembly tries to do something which affects the powers of the High Court, then a governor has a duty, and governor therefore has been given specifically a discretion. That in fact militates against the argument that in the substantive part of provision there is any discretion.
Correct. But there you see, again, the argument of the Attorney General, I'll request you to comment on it. The argument of the Attorney General is that as far as the President is concerned, you cannot question him at all, whether he sits on the bill, how long he sits on the bill, because he's the President of India. But the fact of the matter is the President is just an executive head. He has to act on the aid and advice.
Advice of the Council of
Exactly.
Ministers.
So how can this argument be made? I don't understand.
If I can add here, so the court refers in the judgment to the reports of the Sarkaria Commission and the Punchi Commission. But very importantly, a 2016 memorandum of the Home Ministry,
Yes.
which is like an advisory to all the departments, how soon they should process files. So
Exactly.
those time limits, even for exercising the discretion by the
3
president,
months. 3
that's
months.
right.
That's right.
So that's where the court picked it up from, not just pulled out from the hat and from
Court
nowhere.
said you must follow your own memorandum of 2016.
See, November 4th, 1948,
Yes.
Dr. Ambedkar informs the Constituent Assembly on this, and he makes a very profound statement. He says the administration is vested in the president. Under the draft constitution, president occupies the same position as the king under the English constitution.
That's correct.
He is the head of the state, but not of the executive.
Exactly.
He represents the nation, but does not rule the nation. He is the symbol of the nation. His place in the administration is that of a ceremonial device on a seal by which the nation's decisions are made known. The President of Indian Union will be generally bound by the advice of ministers. He can do nothing contrary to their advice, nor can he do anything without their advice.
Correct. They swear by Ambedkar, but they don't follow what he says.
So, yes. So, I mean, if this is what Dr. Ambedkar said, frankly, this reference is seriously misconceived. And Supreme Court has said,
I'm in fact shocked that the government even made the reference.
because, and this has been, earlier also in many decisions, the Supreme Court has said, there is a difference between 143.1 and 143.2. 143.1 uses the word Supreme Court may.
Yes.
143.2 says Supreme Court shall.
Yes.
Now, may therefore means Supreme Court has the power to return the reference respectfully, saying that we refuse to answer.
They have done so before.
And yes, I respectfully, I hope and pray that Supreme Court this time does it, because this is an indirect way to really overcome the series of judgments of the Supreme Court for last 77 years. It's not that now Justice Pardiwala is speaking for the first time. The governors and president's powers have been checkmated by the Supreme Court long ago. Therefore,
In fact, the way Justice Pardiwala has traced the law is something remarkable. He has traced the law from the beginning. He talked about the commissions. He talked about the memorandum of procedures. He talked about how there's a difference between the 1919 Act, the 1935 Act. I mean, it's such a well thought out, elaborate judgment. And these fellows say that the governor and the president have immunity. Can you imagine? This is part of the reference. What do you say? What immunity are they talking about?
I think even if Supreme Court decides to answer it, most likely it will answer all these points the way this is Pardiwala has written the judgment.
Yes.
But the only thing is it will not be binding on them.
Of course.
And they've said, it has been said now in the Supreme Court, not binding in what? Binding only on policy aspects.
That's correct. That's correct.
But in constitutional aspects, if they have made a reference, they should follow it.
I agree entirely.
draft constitution had originally intended to include in a schedule a declaration of instructions for the governors. But Ambedkar said that this is not necessary because there is no power in the governor.
That's correct.
Therefore, why should such an instrument be attached? So they dropped it. It was there in the draft constitution. So they dropped that, as an annexure to the or schedule to the constitution. That itself shows that they didn't want governors to really go beyond and the word used is governor shall act on the advice of the Council of Ministers. Shall act.
Correct.
President, shall act.
That's
both in Article 53 and 163.
It's not a personal power of the president
Exactly.
at all. Yeah.
So, 74 and 163, there is no discretion left. The word is shall. Otherwise, it makes mockery. It makes mockery if one gentleman or lady is going to say that I will not approve the bill and will of the people because I don't have time. I have time to go to Madras. From Telangana, the Honorable Governor used to be Madras almost every weekend.
And they attend, in fact, nowadays governors attend political meetings and give speeches there.
So,
this is unheard of.
How do they say that they don't have time? They have all the time. What are they doing except attending some ceremonial functions? So I am frankly, I am very, very critical, not disappointed. I would say seriously disgusted by the behavior that if you have been appointed to this high constitutional position, if you can't conduct yourself in consonance with that office, then you are not worthy, you are exposing yourself.
I think his expectations too high from the politics has changed.
I agree. But
values have changed.
Yes.
So therefore, in the present situation, it's only the courts.
Yeah, that's the only hope.
The High Court or Supreme Court which can sort out these matters.
Only hope.
Only hope.
See,
this is how it has been done.
One other issue is important, that Supreme Court has time and again said that once it has given a declaration on law, reference is not maintainable. And there are series of judgments of the Supreme Court giving declaration of law. And by virtue of Article 141, read with 144, everybody is bound by that declaration of law, including the President and the Governor. Therefore, making a reference, I think the government is making a serious mistake in ignoring that law.
Let me just,
please.
Yeah, I have a slightly different take. I think this is very deliberate. It's well thought through from the government's point of view in opening up another legal front. You see, there are two factors here. One is trying to find a legal solution to a political problem. All right. So when the government of Tamil Nadu is encountering a political problem, it invokes the jurisdiction of the court and seeks a legal solution. Sometimes you seek a political solution for a legal problem. For instance, you're facing prosecution somewhere. You politically try to resolve it. Let's say if somebody who's facing prosecution shifts his allegiance and it's happening, then the prosecution is dropped because you found a political solution. Now, this is one of the instances where they're trying to find a further legal solution to a political problem.
You're right.
So, it's essentially a political problem. What they're doing is opening up third legal front. See, we would have expected a review petition, a curative petition, that route. That's still not close to them. But they're opening up this advisory opinion front for a very deliberate reason, because there are still issues involving Kerala,
Yes.
which is pending before the court. They know that when the Kerala petition is taken up, this will be cited as the precedent.
Yes.
Now, if you have the pendency of an advisory opinion, you're going to tell the court till you really answer these questions.
No, you can't do that. You
No,
can't
no,
do
no.
that.
I'm just saying.
They are
from
bound by
no,
that
I'm trying
judgment.
to understand why they've opened up this front. Okay.
Nobody
because
can-
they know an advisory opinion is simply an advisory opinion. In fact, what is also strange is, let us say in the advisory opinion, hypothetically,
Government is not bound by that.
not only government is not bound, Kapil, even the Supreme
Supreme
Court
Court is
on the
not bound
judicial
by it.
side may not be bound by it.
Exactly.
So you're actually trying to seek, if you call it bench hunting or forum shopping, you're trying to see, because you know a minimum of 5 have to hear this advisory opinion. You're trying to see if 5 judges may have a different point of view from the 2 judges. So they are seeking a legal solution through this route. So I'm not surprised entirely by this, but like you say, Dushyant, the Supreme Court will have to see it for what it is. If out of the 14 questions, more than 13 are completely answered in the judgment. One could not be answered because it's not argued before the court. For instance, why did it not go under Article 145 to a constitution bench? That was not even urged before the 2-judge bench. Of course, there is an answer given by Justice Pardiwala in his judgment, in this judgment, even to that. But I'm saying, barring that 1 or 2 questions, and you don't actually come out saying we are unhappy with this judgment and we are actually seeking a review of that judgment. You don't say that. So, like you rightly said, if a judgment completely answers all the questions in the reference, there is no need for this reference at all. But I see it really, they are trying to open up another legal front to get 5 judges of the Supreme Court to think differently on these issues.
No, the thing is,
Hoping that they will think differently.
Dushyant,
Hoping,
the
exactly.
the thing is that they know that in a review it will be rejected, and in a curative, the jurisdiction of the court is so limited that the curative can't go into
No,
this.
these 2 judges will be part of it. So both these judges
Will be
but-
part of the review
but-
bench and the
and the
curative
But
bench.
the curative is only if you're not heard and stuff like that. You know, it's very limited. So they know that that route is not going to lead to anything, which is why they have adopted this particular route. But going back to the issue of one of the questions in immunity, I think people should know that immunity is for personal acts of the governor and personal acts of the president while he or she is in office.
This has been rejected by the Supreme
but
Court
why have
time
they-
and again in Rameshwar Prasad.
But I am saying,
they
why
very
have they
clearly said
referred?
that.
Why have they referred this question? I
No,
don't.
because Kapil, like I
I
said,
don't
no,
just-
it is like buying time. You see, I think it's a device that they're adopting. It's a device available under the Constitution. They're adopting it.
It is taking a pot shot.
Yes, taking a chance, saying, can we persuade the court to see these as political issues? Because sometimes, and it was argued here by the Attorney General, that this is a political issue,
Yeah.
it's a political ticket, don't get into it. And since
How
they-
is it political?
No, since they didn't persuade the 2 judges, they're trying to see if they can persuade 5.
Oh, yeah. First of all, I doubt if they'd ever be able to persuade.
But I can only say one thing, that for a government which professes to follow the constitution, this sends terribly wrong
Who
signal.
says they profess it?
They
to follow?
do. They claim in many speeches all across. They actually follow is a matter of, we all know what it is. But time and again, Honorable Prime Minister has said that, we respect the constitution, we respect constitutional
respect but don't
morality.
follow it.
Exactly. But having said that, I feel that this is in an extremely poor taste. And I agree with Chief Justice Murlidhar that the whole purpose is to, try your luck again. And, in the face of the declared law, which is it's so writ large, it doesn't require any answer. And I'm therefore surprised that the learned Attorney General, whom, I have very affectionate relationship, would have advised the Honorable President of India to seek such a reference. Everybody seems to be failing in their duty.
Well, let me go on to another issue and I'll seek your opinion on that. Right from the beginning, Sarkaria Commission, other commissions said that the office of the governor should not be the office of political appointees close to a particular ideology, but it should be men of stature who have some understanding of the Constitution. Neither the Congress government nor any other government followed that. So the other question I want to ask you is it therefore necessary or hasn't the time come to actually abolish the office of the governor?
If you don't abolish the office of the governor, at least appoint persons who are not politically.
Why is it necessary, the governor's office? Why is it necessary?
I think he is a link between the union and the states.
Well, you can have a link even otherwise.
Yeah.
No, what happens when there is in assembly a doubtful who has the majority?
Exactly. So there are
No, that's right.
No, but Kapil, there are two purposes. In fact, Justice Patnaik has hit the nail. That discretion that both the president and the governor have of
To calling a person.
determining, getting a sense of who commands
is
the
in
confidence
majority.
of the
Correct.
assembly, that's
Correct.
a very, very important power.
Correct.
And in the context, you've argued so many cases on 10 schedule now. That's the second area where they actually interfere, where either summoning the floor test very soon or not summoning it as it should. You have MLAs being carted off to resorts in some other city.
Yeah, that's
and
right.
the governor is not convening, and you have to come to the Supreme Court to say, fix a date for the floor test. So the governor is becoming a very, very critical political player from all angles. So once they've tasted that this is another avenue for manipulating
example,
power, they're not going to give it up.
For example, there is a serious
I have an answer to that, but
there is a
let me see.
serious silent insurrection taking place in a particular state.
Right.
And it is happening in a very, very secretive manner. The governor comes to know, and governor therefore will inform the union, and union will therefore take corrective steps to ensure that the secession of the state does not take place. This, I personally feel that governor's position is very crucial under the constitution, and the constitutional framers really were wise enough to provide that position with limited powers and limited obligations and duties. But appointing, as Justice Patnaik says, that we should have good people, that's not going to happen. Frankly, look at President Abdul Kalam and President Narayanan. Both were not conversant with constitution,
Of course not.
but both were fortunate that they had advice of the finest attorney generals.
That's correct.
Be it Ashok Desai, be it Soli Sorabji, and so they got the fine advice, correct advice, and they acted as per that advice.
Mr. Sibal, I'll tell you something very interesting. Punjab and Haryana Public Service Commission, right? The Chief Minister, I think, of Haryana Public Service Commission, he picked up his friend who was a lawyer, had no experience of administration, a trial court lawyer, and made him the chairman. So there was a litigation in Punjab and Haryana. Ultimately, Punjab and Haryana, a larger bench, a 3-judge bench, appointed a search committee. And then they appointed a retired army person as the commission. That was challenged in the Supreme Court before me. Mr. P.P. Rao was arguing. So, Justice, I think, Lokur was sitting with me. So, there's nothing in the provision. What would be the qualification of Public Service Commission chairman? Nothing is there. Governor's discretion completely. Governor has to appoint. So I developed a new theory of implied limitations. It's a reported judgment. Implied limitations. You have to look at the person who's going to perform the function. What kind of function is to perform? And then you have to see whether the person you are chosen or going to choose fits into that duty. And I laid down the law. That's still the law, right? This is how the Supreme Court can, at a later stage, say, for appointing governor, you must have, there are implied limitations, this is the function is performing, he must have these qualities.
I think
That's not
whatever
likely to happen.
limitations, a man once appointed by a political party is not going to change. Now we are...
See, coming back to that question, and I agree with you, there must be some mechanism. Fact of the matter is now you can prove your majority even under the present system. The court says you prove your majority on the floor of the House. What governors do is to buy time for the government in power to ensure that the majority changes.
Correct.
Right? Now, this is how the governors are acting. Now, you can't limit that power. So there has to be, and I'm not saying that it should happen tomorrow, there has to be an alternative mechanism. Otherwise, governors by inaction change majorities, allow majorities to be changed. In the meantime, they will go to court and they get a stay. And then the whole system. So these are very, very, very. I mean, the governor's role here is so crucial in the making of majorities and the unmaking of majorities. Right? So even if the office is necessary, how do you deal with that?
When constitution makers were making those provisions, they had an alternative, either parliamentary system or a presidential system. In a parliamentary system which you have adopted, there is a role of the King of England, is a role of a governor or the president. You can't avoid it.
No,
But
I know.
limited role.
I'm not saying you can't avoid it. Can there be an alternative mechanism which performs a function which will limit their powers and don't allow majorities to be changed in this fashion? I don't know, but I'm just saying, because office of governor, if the governors act in accordance with the constitution, is no problem. But if they are acting contrary to the constitution at every stage, and I have been fighting these cases from the beginning, right from Uttarakhand, Maharashtra, Madhya Pradesh, in the northeast, Arunachal Pradesh, Rajasthan. How many times have the governors actually allowed majorities to be cobbled up?
Kapil, I think we'll have to go back to the most fundamental question. Despite these governors' actions in Maharashtra, the Supreme Court actually passed strictures on the way the governor had behaved.
And see what happened.
In this judgment, in para 432, they say this governor repeatedly disobeys our orders.
Yes.
And which is why they don't send it back to him. There's a whole paragraph on the
They
content.
in fact give assent to the bills.
No, and they say his actions are not bona fide.
Yeah.
But what happens politically is something else. Despite these kind of things, those governors are not asked to demit their office.
Yes.
They're not replaced. So the message that goes out is something else, that we don't see as a political class the governors acting,
outside the constitution.
outside or out in contempt of courts. Which is why the fundamental question is this. Today, if you asked all the political parties, would you want to change the kind of change you're looking to see? Would you want to change the provisions of the constitution to limit either the powers or functions of the governor? I don't see any political party frontally coming out and saying, I want an amendment to the constitution on this.
Kapil,
Maybe so. I'm only.
Kapil, answer is this. Ambedkar said that this is a fantastic document, the Constitution of India. And if it fails, it will fail because man has become vile.
No doubt.
Now, look at Supreme Court of India. How many times Supreme Court has, failed to follow the constitutional provisions and given wrong judgments? How many times Supreme Court has failed to uphold fundamental rights of the citizens and protect their, liberty? How many times CAG has failed? These are all constitutional positions.
Right.
So, unfortunately, it is the man that has become vile, and there is nothing we can do to improve unless we improve ourselves, which is impossible. So, I think
Supreme Court also has got human judges in other cities.
absolutely.
So they have their
I agree.
frailties, some they have their firmness.
Absolutely.
So whoever is firm, good development, good judgment.
Actually, this is a classic instance of the tension of separation of powers.
Yeah.
So when the court steps in to say, in a confrontation between the state executive and the state legislature, we will try and tell you what the law is. They elevate the dispute to a different level and keep the tension alive. Now it's a tension between the union government and the Supreme Court.
See, for example, they say that how can 32 petitions be filed by the state?
Yeah.
But I'll tell you an example where, Uttar Pradesh as a state filed a 32 petition in Supreme Court to get a particular criminal who was in Punjab jail to be transferred to.
We know
And I appeared, Mr. Rodgi also appeared, we argued that state's petition is not maintainable. And Supreme Court said nothing doing. State has a right to.
Ansari
Yes, state has a right to, and ultimately he was taken and I think he's killed.
Yeah. He was. Yeah.
So,
That's another story.
So, and Supreme Court rejected this argument. They said, no, state has a right to file appeal. So, it is convenient for the party in power today that when they want Supreme Court, they will file a 32 petition. When opposition state file, they say it's not maintainable. I think let us hope and pray together that the Supreme Court returns this reference and reaffirms what the law is and what the Constitution is.
Well, as you rightly said, ultimately it's the men in power. Wherever they are. I mean, men in power in the executive, men in power in the legislature, men in power in the judiciary. It's those men in power stand up to the Constitution. We don't have these problems. Unfortunately, they fail
Yes.
many a time. Thank you very much.
Thank you.
Thank you so much, Kapil.
Thank you.